A warm welcome to all of you here today on this not so warm afternoon, probably for most of us around the country. And welcome to our talk on key considerations for procuring waste collection contracts. I am Julie Lau, and my colleague Sally Stock is here with us today. And both of us are partners at Sharp Pritchard, and we'll be speaking to you about the different topics we've got lined up for you today. As I mentioned now, our email addresses are on the front cover of the slide deck, which you will receive in due course as well. And also along with the recording of this session, that will also be made available once that's ready. One quick thing to note in terms of logistics or housekeeping is that a couple of things actually. Firstly, that given the hour we've been allocated and there's quite a lot to get through, we won't be able to take any questions and answers sort of live, but we're very happy to look at them afterwards. So if you do want to pop anything in the chat as we're going through, we'll take a note of that for later on, or similarly, you could just drop us an email as well if you want to kind of have a further discussion about some of the topics that we're covering today. And the other thing is, sort of halfway through the session, towards the end, there are going to be a couple of interactive bits, so just questions to get people thinking about some of the topics we're talking about today, and to kind of facilitate that, we're going to be using Slido, which is a program where you can pop in your thoughts into the ether in a way, and it'll come up on our screens here. So just to let you know, if you've not used that before, to have probably the easiest way to have a mobile phone handy to scan the code that'll come up on the screen at that point, or you can also just use a computer, use your normal browser. So look out for that. For now, we'll get started with our talk. So if we move to the slide on the learning outcomes, please. Thank you. These are the 4 sections of the talk we're going to be of the area we're going to be talking about today. We're going to start with looking at the law, not forgetting that we are lawyers here talking about waste, of course, but we'll look at the kind of black letter law and some of the forming the basis, the framework for what we're doing in this sector. Then we'll look at some more practical points in sections 2 and 3. So looking at what we consider to be a checklist of important factors. Sally will take us through some of the key commercial positions that we think are really important to talk through with the waste team, with the procurement project team, when re-procuring waste collection contracts. Similarly, the other side of the coin, we're going to look at what we think are key issues we've seen that the waste industry consider to be sort of thorny issues, things they really want to talk about when they come to the dialogue table. And then finally, we'll end with looking at the areas where we think there might be risk of challenge from a procurement perspective, and just generally challenge to the procurement process, and think about ways to mitigate those and to avoid them. So we'll head straight into section 1 with the black letter law. And here are 4 pieces of the key legislation, I would say, right now, today, we should be looking at when considering waste collection. You go way back to the 1990 Act still, but equally in the 4th bullet point, it's important to consider that obviously quite a few changes have been made to that 1990 Act via the Environment Act, and a lot of those amendments are still coming into force as we speak, almost this year, and some haven't yet come into play yet. So really kind of a practical point for lawyers, those who are actually having to delve into the legislation, is making sure that you've got an up-to-date version of the EPA 1990, because it is literally being amended as we speak. Similarly, with the Environment Act 2021, just being mindful that you need to have a copy that kind of lets you know which provisions are actually enforced, because some are, some aren't, and that sort of thing. And then, yeah, the other 2 pieces of legislation we'll cover in a few minutes as well. So if we hop straight into seeing how this legislation is relevant in the next slide. So just back to basics, and this is maybe really obvious for some of you, but conscious that we've got a wide range of audience today. When we looked at the attendee list, we've got everyone from lawyers who probably know a lot of this stuff to waste collection, waste officers who will be a lot more in the know with the kind of practical commercial things that we'll be talking about later, as well as procurement officers who will of course be very much aware of the procurement risks that we'll cover in section 4. But just to make sure that everyone is on the same page, really, as we're kind of, Sally and I have approached this talk a little bit like what we would do with clients when we sit down to start a re-procurement. What are some of the key things, that the basics we need to understand, and then the key issues that we all need to know. So yeah, forgive me if some of this is basic to you, but who is a waste collection authority? Those are the different, it's different in different parts of the country, but there you have it on the screen, and section 30 of the EPA is where you go to get that legislative framework for that. Obviously, some unitary authority, there will be unitary authorities who are both a waste collection authority and a waste disposal authority. Whereas in two-tier areas, you'll have the collection authorities who are, for example, the district councils, and then you'll have your disposal authority, a separate entity, usually then in that arrangement, the county councils. The two do have to work together quite a lot, the two entities, even if they are separate ones, particularly to create joint municipal waste management strategies. And that's where the WET Act, the Waste and Emissions Trading Act, comes into play. Next slide, please. So what can today's talk is really focusing on the WCA, Waste Collection Authorities. What can they do? What powers do they have? So we'll start with this one here in section 46 of the EPA, looking at what, firstly, the Waste Collection Authority as its very kind of primary function really in this area is that it can specify the bins effectively, where the waste must be placed, when it must be placed there, what kind of bins are used, where it gets collected, where it gets pushed to be collected, all of that. That is the kind of, this is the legislative basis for a collection authority having the power to do that. Next slide, please. And then we look at other powers that the WCAs also hold under the legislation. So you've got the retaining of waste for recycling. So the WCA has the right to retain household or commercial waste for recycling rather than passing it straight on to the disposal authority. Although there's some, as you can see in the second and third bullet points there are some caveats or some kind of administrative hurdles one must go through to do that. And then in terms of industrial waste, there's another power there that WCA has the power to collect that industrial waste if it's been requested by the producer of that waste. But again, there's a hurdle there in that you do have to get the consent of the relevant WDA. Next slide, please. Another power, this one we often are asked to advise on. When can you charge and what can you charge for as a WCA in carrying out these duties, or do you have to carry these out anyway? So in general, for just the general collection of household waste, from the curbside, you don't charge for that. Where you do have powers to charge under section 45 of the EPA are charges for collection of commercial and industrial waste. Again, that's when requested by the producers of those, so the commercial producers of that waste. You may charge for certain types of household waste, and I've given some examples there, but that isn't the exhaustive list that's set out in Schedule 1 of those 2012 regulations. So you need to go to that to see whether the waste, and sometimes it's not about the waste itself, but it's rather where it's been generated and where it's being collected from. So for example, the University Hospital Prison example, that's where you look at. So it's not necessarily the type of waste, it could be the location. And then the final bullet point in there as well, something that collection authorities do sometimes just need to kind of refresh themselves in terms of what the legislative basis is for the ability to charge for the receptacles that they instruct the waste to be put into. So you may charge for that, but obviously a lot of authorities choose not to charge for that. And if the legislation allows for 3 options, you can charge for them, provide them free of charge, or require someone else, the householder, to provide them. I think the first 2 are probably the more often used ones. And then we'll move on to the next slide, which now turns to the other side of the coin in terms of legislation and looks at the duties of the Waste Collection Authority. So quite obviously, the duty is to collect household waste, and if requested, as I said, the other types of waste as well. the WCA's duty is to deliver that waste to a place specified by the WDA. So, for example, to a delivery point or to their disposal points. And in England, you must also comply with directions from the WDA about the separation of waste, which actually takes us nicely to our next slide around, because now, as we all know, there's been a lot more around separation introduced by the Environment Act 2021. And there's a lot of legislation you'll see in the next few slides. So take your time when you actually get the slides to kind of pour through them if you need to. But a lot has been, new sections have been introduced into the EPA, as I've said. But you also have to look at different regulations to see how they come into effect. Effectively, the bottom line is that this concept of simpler recycling is what the government has called it, but effectively is the requirement that household waste, that underlying principles that household waste is to be collected separately to enable better recycling, efficient recycling to take place. So that's the sort of bottom line, and that you've got the law for that there in the first bullet point. In terms of what is meant by different types of household waste, what is recyclable, and all of that, all the definitions that kind of feature, all the defined terms that feature in those pieces of legislation, for the definitions of them, you then turn to the separation of waste regulations 24 in that second bullet point. So the two go hand in hand. So that's the starting point, legislation-wise. And then if we move to the next slide, then we'll look at the actual timescales for some of these things, this separation to actually take place, and also just being mindful that there are some caveats around that separation, because obviously government has been quite clear, or at least the previous government, I don't think things have changed since, that they don't mean that everything has to be necessarily, at least for now, put through all these different streams. There are caveats at the moment around how that separation can take place. So there is some flexibility for a combination of some of those waste streams with recyclates in particular. So the timelines we have at the moment, and these are the ones on this page, are set in legislation now. So the commencement number 9, the EA21 commencement number 9 regulations I mentioned earlier, they were made earlier this year, I think in May, and they now set in stone the 31st of March 25 deadline for the collection of dry recycling and food waste separately from businesses, with the exception of very small firms with about 10 employees or less. They've also set in stone the 31st of March 2026 deadline, the one that probably most of you will be familiar with, for the collection of dry recycling and organic waste from households. However, as some of you will also be familiar, there is a caveat to that. So for some local authorities, for some WCAs in some localities, there are some transitional arrangements that mean that you have a slightly later deadline, or in fact, in some cases, a very much later deadline than that 2026 one for the separate collection of food waste. And that's been put in place to allow certain WCAs time to align their food waste collection, their separate food waste collection, with existing long-term waste disposal contracts for those areas. So a couple of years ago, DEFRA wrote to all the WCAs and asked them for kind of justifications for why they might need an extension on that date. And actually, if you look at Schedule 1 to those number 9 commencement regulations that I talked about earlier, you will have that whole list of named WCAs and the specific dates that apply to them. And some of them do actually stretch quite a while from now, I suspect, to align with the expiry of their PFI contracts or their kind of long-term waste disposal contracts. We can move on to the next slide, please. Now, here are some of the caveats, or some of the dates that are maybe not quite as at the forefront of everyone's minds just yet, but the 31st of March 27, at least in the draft version of the regulations I've got on screen there, says that for those micro firms I talked about earlier, that's the date for when dry recycling and food waste from them has to happen. And the same date as well for in those other regulations there, the separation of waste regulations, those are laid, not draft. Those ones set the date for the collection of plastic films and flexible plastics for for households and non-household municipal waste. So basically from everyone, collection of plastic films and flexibles is to happen on that date, from that date onwards. So that's your timeline and the legislation to go with it. Then in the next slide, and the final slide of this section on legislation, is just to kind of flag up that there are the changes that obviously the Environment Act brings into force in terms of waste. Obviously, the environment actually is much bigger than the waste area, but just even in the waste sector, there are some bits of it that we haven't yet seen full clarity on the detail. They're mentioned in them, and DEFRA has talked about them in stakeholder updates and things they've put on their website. But we're still, other than knowing that, for example, electronic tracking of waste is expected to go live next year, there's not much detail yet on that. I think they have confirmed very recently that that is still the plan. Similarly, obviously, there's been a lot in the press and in industry presses as well around the EPR and the DRS schemes, which again we would suggest keeping an eye on. We don't have much again about exactly how they will be implemented and how that will impact. I think the key thing for WCAs is to understand and be mindful of the wider impact those schemes could have on your waste volumes and composition in terms of what you collect at curbside and household recycling centres. And with that, I'm going to hand over to Sally to take a look at some of the important factors to look at the start of a procurement.
Thank you, Julie. Okay, so yes, at the beginning of any procurement, we'll sit down with our clients and we'll go through a list of sort of key considerations. We've picked out just a few of those which we think are most relevant for you today. So starting as you would with any procurement, but it is sort of perhaps more applicable on or more important on a waste procurement is the strategic outcomes and objectives. So the reason I say that is that it is quite a political area. It's an area which gets quite a lot of attention from residents, and members also often take quite a keen interest. So it's quite important to get an understanding of those political drivers and make sure that that is embedded fully within the procurement as necessary. The other thing to think about, obviously, with those legislative changes that Julie was talking about, that can mean changes to the method of collection, more containerisation or changes to containerisation, which can equally can have an impact on members, residents, and how they perceive the new service to be run. So it's a good starting point, I think, for your procurement. Next slide, please. Now, just thinking about some of those first things, which you'd obviously, contract period is something you'd think about in any procurement, but for a waste collection contract, there may be other related contracts you also should be thinking about. For instance, the related disposal contract, so where this waste will go to. Depots, if you've got a depot, and it's not, you don't own the depot and you've got a lease for that depot, what is the length of that lease? Do you need to think about extending that lease, or are you looking at alternative depot premises for this contract? The other thing that quite impacts upon that contract period is the lifespan of the vehicles. So RCVs generally have a lifespan of around 8 years, or it's considered to be around 8 years. Some can last longer, but if you're thinking about procuring vehicles at the beginning of a contract, and you've got a 10-year contract, for example, and those vehicles are coming to the end of their useful life after 8, you'll be looking to reprocure towards the end of that contract. So it's not always, it's quite often, or it's a good idea to try and align the contract period with the potential lifespan of those vehicles, because you could otherwise be procuring new vehicles towards the end of the term, and then you may have an issue over ownership of those vehicles, and who pays or who funds for those vehicles. So with that in mind, it's a good idea, and a good idea anyway, to engage early and with market engagement and seek feedback. So bidders often have something to say, or economic operators have something to say about the contract period. And just thinking about vehicles again, so I'm gonna keep coming back to vehicles. They're quite crucial. But do you have vehicles? So does your incumbent contractor have vehicles which the council owns, or does the incumbent contractor own all those vehicles? Will you have vehicles handed over at the end of the contract, or will you be able to offer some vehicles for purchase? So discuss that with your incumbent contractor to see if they'd be willing to sell them on to the new provider. Then think about funding of the vehicles. I'll come on to that again later, but who's going to fund those vehicles? Are they going to be funded by the council or by the contractor? Other key considerations would be about the timing for the procurement. So obviously, do you have enough time to procure? When's your current contract end? Do you have enough time to have that procurement and a mobilisation period before the contract ends? If you don't, start looking at extending that contract. Then have early engagement with the current contractor. I know you'll be engaging with them day to day, but it may well be different parts of that company that will deal with the exit provisions. So start looking at the exit provisions in your current contract. Think about workforce information, ask for it within plenty of time, get an understanding of that workforce information and be able to check through it to be able to see if, do you think if anyone's missing from there, or just get a bit of a sense check of it. Also, coming out of that workforce information will be whether there's any eligible employees for LGPS purposes, is the current contractor an admitted body, and then start thinking about whether you'll require actuarial assessments prior to for the procurement purposes. And looking at pension contributions and who's likely to take on the risk of those pension contributions. Now, if we can go to the next slide, please. So this is just this slide is just for graphic purposes, but really just the key is to plan with any procurement. So there's nothing new here, but just think about key considerations. Think about milestones, so key milestones along the way, internal decision-making points, and board engagement. And you need to think about who can make decisions at the different stages of the procurement, and what decisions need to be taken back to which of your internal approval processes. Also consider, this has come up obviously quite a lot recently, but just also consider any elections during the procurement period and just what impact that may have on your procurement. Next slide, please. Again, this would apply to a lot of procurements, but really don't underestimate the amount of work required, particularly in the early stages of the procurement, and if you're running a dialogue during the dialogue period. But you really need to think about whether you need any external support. This may be in terms of technical support. So the in-house team will have a really good knowledge of the current contract and any changes that are required to that service, but they may not know so much about the market as such. And technical advisors can, give you that knowledge of the market, current trends, and help guide you through. Equally, financial support, where you're getting your financial support from. Do you need help in building up the financial, the pricing tables? the financial models that sit behind these contracts are normally quite complicated. So sometimes, there isn't the internal expertise for waste procurement, and it might be worth appointing someone to advise there. Equally, obviously, legal support. We provide. We work on a lot of waste collection contracts, as do other legal advisors, and that there's quite a few sort of nuances around the waste industry and getting to know the waste industry and the relevant providers. Next slide, please. One of the documents, which seems so obvious, but it gets forgotten, so I just wanted to just raise it. The specification, it is the backbone to the procurement. And I'm not saying people forget the specification, but they forget how early on in the process it's required. It really is required at the beginning. Particularly if you're looking to change your service, and we've got the legislative changes, and you need to think about how that's going to be incorporated into your new service. But all the other documents will need to sit with that specification, so they need to dovetail with it. Flowing directly from the specification, you've got your performance management, so reporting requirements and KPIs, and you've also got the service delivery plan requirements or meta statement requirements, which will require bidders to bid back on. It will form the basis of your FTS notice or your tender notice, contract notice going forward, and it will also form the basis of your pretty much all your documentation rests on the specification. Until the specification is drafted, you won't really be able to finalise anything else. Next slide, please. Thank you. Right, this is the last one in the key considerations section, but just thinking about the property. So the council, do you have a depot? It seems very obvious, but quite often what we found, the depot may be owned by the incumbent or leased by the incumbent, or the council may own the site, but there is provision to move that site or move the depot, and then a new site hasn't been secured. So it's really important to think about where this contractor will be and where this contractor will be throughout the term of the contract. They will expect you to provide a depot. It depends really, I think, on your area as to how much if there's any sites available if you don't own one. Then also just think about fitness for purpose. So it might work for your current contract, but will it work for your future provision? Are you requiring some alternative fuels? So you're looking at electrification of your vehicle fleet. If you are there suitable provision within that depot or capability within that depot to charge the fleet? And storage facilities. So if you're looking for a change to the containerisation, is there going to be anywhere on that site to store containers? So very practical points, but all things that need to be considered quite early on. Also, just think about the usage. Are they going to be sole tenants of the site, or is there going to be joint use? A legal point of just thinking about the contamination. Is there current contamination on the site? And who's going to be responsible for any contamination during the term, and who insures? And a lot of that will depend about repairing provisions for the property. Next slide, please. So now we're just going to move on to thorny issues for waste collection procurement. So we're really thinking about what areas cause bidders the most amount of concern. And this is where we're going to do our first Slido. So if you use your phones, you can scan in, use the QR code and scan that in on your phone, or you can type into your browser www.slido.com, and then you'd need to put in that number. Now, what we wanted you to do is just just put in anything you think it would be commercially significant for the waste industry at the moment. So anything you can think of that may cause some concern in a waste collection procurement. We're going to go, if you want to just start typing away, they should just pop up on the screen. We'll talk to some of those, and then we're just going to talk about some of the points, probably things you've already thought of, but also things, we're going to go through some of the points that we've had on recent procurements that have come up and in the following slides. Okay. Absolutely. New legislation. So EA and the implications of the EA and changes in law is certainly a key topic for bidders at the moment. It's one we'll come on to, and obviously Julie's already had has gone through some of those with you. Available contractors, that's interesting. That's the market itself and how many contractors there are out there. There, I think you need to think about when you're running your procurement, you need to think about how you structure it to encourage as many participants as possible, but also ensure participants are not knocked out too early on in a process. Indexation, yes, absolutely. Indexation is certainly something that comes up a lot, and bidders are nervous around indexation. We find in a lot of procurements a basket of indices is used. Lease for depots, absolutely. Depots are a key point. I've mentioned it already, and I'm going to come on to that again. Ownership arrangements for assets and vehicles too is also a key point.
And I see mobilisation and transferring from the incumbents, Ali, again, something that we'll talk to briefly in the final section, but that's often a key thing that comes up in dialogue in terms of how much time one has, and has that all been thought through as well?
Yeah, absolutely. Yeah, absolutely. Agree with all of those points on screen. They are all things that come up quite frequently in procurement processes. Okay, I think we'll probably close the Slido now, and we're gonna have another one shortly. Now I'm just going to take you through some points that we've had come up on recent procurements, and just sort of some considerations for you. So first of all, really vehicles. I mean, vehicles are a large percentage, or comprise a large percentage of the overall cost of the contract, and so the funding of those vehicles is quite key to bidders. We often find councils want to know how much it's going to cost for the contractor to purchase those vehicles as opposed to the council to purchase, and they ask for options within their procurement. That can cause difficulties, and there are ways to get around that, but you need to consider that as part of your procurement process to ensure that it's open, fair and transparent. Also, then once you then need to think about procurement of those vehicles and price fluctuations. So that's really if the contractor will purchase those vehicles, because normally they have the best buying power, but then the prices may fluctuate from the point that they submit their tender to the point that they actually place that order. That will depend partly on the mobilisation period and whether there's any vehicles available for them at the commencement of the contract. You need to consider maintenance of those vehicles. So if you've got an aged fleet, a mixed age fleet, so you may have some council vehicles at the commencement and new vehicles, that obviously they're treated differently, and there may be question marks over the amount of maintenance required of those council's vehicles, so the existing fleet that have come over to the contractor. Then thinking about replacements, I mentioned that earlier. The lifespan of the vehicles is of the RCVs is roughly about 8 years. So if you're looking for a longer term contract, so 8 years perhaps plus another 8 years, who's going to pay for those replacements, and when will you agree that mechanism? The timing of decisions, so how quickly will the council respond to the contractor if they require a replacement vehicle, and then if they require advance payment, do your processes allow for advance payment, and if so, what do you require to protect the council from paying in advance? Hand back at the end of the contract, and in the event of insolvency, consider what's going to happen to those vehicles. Should at the end of the contract, are they the council's property? They will be if the council's funded them, but do they get handed back to the council? Will they be available for the new provider? And then just thinking electrification, I should really say alternative fuel vehicles there probably. So think about hydrogen vehicles as well. Next slide, please. Again, we've mentioned depots already. Similar thing here that gets brought up by the bidders, and they raise concerns over the condition of those facilities. So have you got condition surveys available? Are the facilities fit for purpose? So, okay, they are fit for purpose for the incumbent contractor, but are they fit for purpose for the new service as well? I've mentioned electrification. Are there points for electrification? Do you have a depot? I should have mentioned that first probably, but do you have a depot? And then the lease terms. Bidders will expect to see more than heads of terms. They will expect to see the lease. So you can produce heads of terms certainly at the early stages, but they will expect to see the lease, and they are likely to comment on the terms of that lease as well. They will want to carry out due diligence on the title. And then also just consider whether you've got any other premises available, for instance, barrow stores. Depending on the type of services you're including, there may be other sort of small premises available. Also think about if you're planning on moving the depot at all during the contract period, the mechanism for doing that and how much information you have available for bidders at the start. If you can go on to the next slide, please. Another key consideration is ownership of waste. This becomes quite a hot topic for bidders. Generally, the authority will own the waste. It's the authority's waste that gets collected, and ownership will remain with the authority through to disposal. However, in some contracts, depending on how that waste is split out, it may be the contractor's responsibility to manage some of the waste and for the onward disposal of that waste. For instance, dry mixed recyclates or dry recyclates, and it may be for the contractor to deal with the onward disposal, in which case they may take ownership of the contractor retained waste. Is the contract exclusive? So is this going to be the only provider for the collection of the waste? Bidders would expect it to be, but in some cases it isn't, because the council has contracts with other providers providing similar services within the borough. For instance, collection of waste from the council housing properties may be different, but dealt with differently, maybe dealt with by a different department. So just be mindful of who else within the borough collects waste. Next slide, please. Changes in law. I'm not going to go into this in too much detail because obviously Julie's talked about the current changes, but really what you want to think about here is what is foreseeable at the commencement. So either it is already law, or it's sufficiently foreseeable at the point that you're going out to tender, but bidders should be including it within their tender. So generally that's made very clear to bidders. They will push back. This is quite a key area for them, particularly at the moment. But also think going forward, are there any things which you want them to price in and to make sure that they have included? Generally, bidders want to draw a line in the sand as to when the changes in law, the point at which it's foreseeable. So they will want that to be the point at which they taken as the point when they submit their tenders. So anything that comes in after that, then the risk would come under a change in law provision, and therefore the risk is effectively shared or pushed to the council. So just bear those things in mind. Other things that are sort of key topics at the moment: UK emissions trading scheme and the volatility around fuel prices. Next slide, please. I won't say too much on this one. This is pretty similar for any procurement, but TP and pensions, there's a relatively large workforce involved, and bidders are keen not to take on too much risk. So you need to think about indemnities and risk in relation to pensions and contribution fluctuations. The workforce information is unlikely to be the council's, so wouldn't be warranting that data. And now just moving on to the next slide, this is just my final one. Other things just to bear in mind, and they cause bidders concerns, are interface with fellow contractors. So not just the disposal contractor, there may be other contractors, they may share sites with the other contractors, that you may have arrangements for collection of hazardous waste, by way of example. Other things are relief from their obligations and compensation events, termination provisions under the contract, and compensation on termination. So if there's termination as a result of something that the council's done, what compensation are they likely to get? They're going to be worried more if there's if they have they're going to be worried more if they have purchase the vehicles themselves, and what would happen if the contract comes to an end early, indemnities and insurance provisions generally. Okay, I think that's the end of mine. I'm just going to hand back to Julie.
Thanks, Sally. Lots to think about, as you can see. Good checklist there for us all to think about at the start of a procurement. So we're going to think about running the procurement now, and particularly, I guess, towards the end of the procurement. What are some of the areas of procurement risk? What are some of the areas we think challenges might arise? So we're going to do another Slido just to get us thinking again. What do you consider to be the key areas susceptible to procurement challenges in waste procurements? I mean, they might be the same key areas as other types of procurements, but particularly in this area, what do you think are the key areas? So please use the same, so scan the QR code or go to slido.com on your browsers, enter the number, and yeah, I'd be interested to see what you all think. I'm not surprised the Procurement Act is the first thing that comes up. Definitely. The transparency requirements under that, we'll need to navigate those very carefully. Actually, we don't have the chance to delve into that too much today, but certainly is an area that I think going forward, local authorities will need to be really mindful of just knowing when notices need to be issued throughout your process. Over here at Sharks, we have a sort of map, a road map of every juncture during the procurement and at which notice needs to be issued. Someone jokingly said you kind of need to issue a notice every time you sneeze under the Procurement Act. So yeah, being really mindful of that, definitely. Incumbent knowledge, yeah, that's a good one as well. Just being well, I think that goes to fair treatment, isn't it? Just ensuring that everyone's put on a level playing field. So that actually comes to some of the points that Sally was talking about before, gathering all that you have already by way in terms of 2P information and all of information about your waste itself, the operational side of things that helps with ensuring that everyone is on the same page. Absolutely. And also just really how you run your procurement in general, just to ensure that everything is transparent and fair. Quite a lot about variations. Again, not a point that I'll have time to cover today because we've mainly been thinking about the outset of a procurement, but absolutely that is an area that we get asked to advise on a lot as well. How to, with a lot of these contracts, they've been put in place for quite a few years, but they are such big services that often it's preferable to modify or needs to be modified to take into account something, for example, changes in policy and legislation, or it needs to be extended because actually they are such big services, and sometimes thinking about reprocuring it just needs a little bit more time. So definitely that's an area that that we are asked to advise on a lot, and therefore an area that needs to be carefully looked at in terms of an area of challenge. Evaluation criteria we'll be talking about for sure. Feedback we'll be talking about.
Scoring, yeah.
Yeah.
And just on the modifications there, just also modifying, looking at any modifications of the current contract if your mobilisation period isn't long enough. I mean, I mentioned that earlier, but that's when Reg 72 might be applicable.
Absolutely, and then you hope that you've got something in your contract that
allow
you to do that. Yeah. And then, or it's a risk balancing exercise sometimes. If you know that you've got a procurement in the pipeline and it's happening very soon, it just can't happen quick enough to allow, you just need a little bit more on the current contract. That sometimes is a good justification if you can show that you are very much on track to procure. Okay, that's really, really helpful. Thank you, everybody. Some extra things to think about as well, but yeah, we'll pick up on some of these as we in the next few slides. So if we move on to the final section of our talk, that'd be great. Thank you. So yeah, so section 4, the final section is about areas of procurement risk. So one of the areas we were thinking about when Sally and I thought about that question was the shortlisting stage, actually. And right at the start, when you make a decision around what we currently call the selection questionnaire, different term under the Procurement Act, of course, we'll have to all get to grips with that. But effectively that same idea where you apply some conditions to say whether someone's going to be allowed to submit a tender in the first place. When you make that decision, how many people do you think you're going to let through to be invited to tender? That's an important decision, but one that needs to be made then in tandem with whether or not you're going to be reducing the second bullet point there, whether you're going to be reducing the number of bidders later on. So after they have been invited to tender, say you invite 4, will you then be wanting to reduce to 3 at some point during dialogue if you're still running your process under the current legislation, or the competitive flexible procedure still allows for stages under the new Procurement Act? So will you be planning to do that? Because that will necessarily then impact on how many people you want to bring through right at the start. So for example, if you've decided that actually you will not be reducing numbers at an interim stage during a multi-stage process, you might want to just keep that number to a manageable number right at the outset when you choose to take people through after selection stage. That will necessarily mean, of course, that you'll have to devise the appropriate selection questionnaire questions or conditions of participation. You'll have to make sure they're proportionate and relevant and appropriate for allowing you to take through, for example, the top 3 scoring ones, and you'll have to introduce scored questions then in your questionnaire rather than just kind of the basic for information type questions. So that is something to think about in terms of how to make that decision. I think some of the factors to think about, well, one of them was picked up earlier actually in the Slido cloud. It's the second bullet point in there in terms of how many are likely to bid in the first place. So how many bidders do you have in this market? I think this is something that maybe the waste officers will be more alive to in terms of what is the local market like for waste collection contracts, or if your contract is waste collection plus something else like street cleansing or other ancillary things, what are the likely key players in that market in your locality? That will help you think about, actually, will you be getting that many anyway, and you know, what sort of numbers are you likely to receive in the first place? And then going back to your first bullet point, if you do want to kind of have iterative stages and reduce people and all that stuff, do you have, or if you want to keep your numbers at quite a kind of a larger number of bidders, do you have as an authority the time to do that in your capacity as an authority, but also time in your procurement timetable, being mindful of things like the mobilization period that Sally mentioned earlier as well, and the time for buying vehicles. So those are some of the things you have to have at the back of your mind while making that sort of decision. The other couple of things we would kind of advise you to think about is in making this decision is, are there commercial decisions that have been left open that have to still be taken by the authority? So for example, on vehicles, and Sally talked about financing and deciding who's going to be financing that. Often we found that authorities are not quite sure yet early on at the outset which way they want to go, and they like to have a bit more time to think about it. They want to see a bit more, and I'll come to that later on as well, in terms of understanding more to make that decision. If they want that time in the procurement, then you just need to be mindful that if you're going to be making changes later on, or kind of pinning down your answer, your some of these, you're going to be refining some of the specification, effectively the requirements later on, just needing to be mindful that if you've shortlisted and you've reduced people at certain stages while some decisions were not yet made, the impact that will have on the risk matrix for you from a procurement perspective, that needs to be taken into account as well. Similarly, if if you're not completely sure about your award criteria at the start, and we'll talk a little bit about the kind of flexibilities around that, again, if you then reduce the number of bidders, that will again have an impact on when you consider whether you can refine your award criteria or make changes to it later on. You'll have to consider if anybody had been knocked out at an earlier stage while the criteria was different, and would that have impacted them? So all these you kind of have to go ahead, look ahead, to understand the decision that you have to make at this point in the outset. Next slide, please. So in terms of evaluation criteria, that's another area that we think needs to really be looked at very carefully, is an area of procurement challenge, probably not just for waste contracts and waste procurements, to be fair, but definitely one to be mindful of here. So obviously the basic thing around evaluation criteria is to be really upfront, to be really transparent, to set and publish everything at the outset. But of course, there are, as we all know, with complex procurements, they're just, you're looking at sub-criteria, sometimes sub-criteria, weightings down to little percentages. It is not straightforward, and I'd be naive to tell you just set everything and don't touch it. And in fact, under the Procurement Act, Section 24 actually legislates for you being able to refine that award criteria. The guidance, government has issued guidance explaining what it means by that, and sort of the tweaks you can make to add sub-criteria or expand on what you meant by a particular sub-criteria, and even change the weightings within ranges, for example, if you provided a range up front. So that's great that you have that flexibility. Just be really aware that firstly, you need to say, under the Procurement Act, you need to say that you are planning to, you may well use that right under Section 24 to make changes. So your procurement docs need to be really clear about that. But also, this is the point that the two kind of howevers, the 2 points to bear in mind, and this goes back to my point earlier about thinking about whether you want to reduce bidders, and when you do that, and how many you want to reduce to. You need to make sure that any refinement that you make to your award criteria has to take place prior to suppliers submitting final tenders, but also that it would not have allowed, if that change would have allowed a supplier that did not make it through a previous round, it would have allowed them to do so. And obviously that's a bit of a hypothetical exercise you'd have to take at that point. But if this change effectively is that substantial that actually someone might have been able to make it through previously, then you can't make that change. So this is why actually sometimes it may be worth just cutting numbers at the right point and then actually taking them all through your iterative dialogue stages to take away the risk of this happening. And then you might want to think about when you set your evaluation criteria. So being upfront about the fact that you need some flexibility, even under the PCR currently, just being really transparent. If, for example, there are certain elements that you wish to score in an initial tender submission round, but you think actually when we come to final tenders, we might well drop that out because maybe it's less important at that point. Build that into your evaluation criteria. Just be really upfront about it, so that effectively, from a kind of litigation perspective, you've started the clock running by being really upfront, and that is what you intend to do. Can we move to the next slide, please? Thank you. So then when you actually carry out the evaluation, just now that was setting the evaluation criteria, when you carry it out, obviously, again, the basic thing to note is follow the evaluation criteria that you've gone to pains to, be really clear about, really transparent. You've put everything you're planning to do and may need to do and reserved all your rights in that criteria, then apply it. Unfortunately, this is still the area that is probably the most common area of challenge throughout all types of procurement, but certainly in the waste sector, I think because the evaluation is that detailed, the quality questions are often in tier 3 level. There is just so much that it's so easy to trip up on. So I think the key message here will be to ensure that those carrying out the evaluation, particularly if it's not something they do as part of a day-to-day job, which probably they wouldn't be doing, that they are very clear about what their role is, what they have to do, that they adhere to what's been published, and that they expressly use that when they write down their rationale. So when they put a score of a 4 out of 5 or a 5 out of 5, and they explain why they've given that score, it really has to be driven home that they use the scoring matrix that's been published. They use the words from that scoring matrix, not their own kind of prose around how great a submission was, and that is so important, and we can't stress it more, which is why it's in bold. Because when Sally and I were thinking it through, this is an area that we do have to advise on quite a lot, and it is easy to trip up, and it's just something that I think with adequate preparation, training, that it's something that can be done really well. So equally, there's the moderation process, which is around making sure that has been done properly, a kind of final check, making sure everyone's scores and rationale makes sense, everyone's happy, and everyone can come up with an agreed consensus final score and rationale that can then be sent to bidders and published. That's really important. So I've just flagged up a case that has talked a bit more about the moderation process. It also talks about actually carrying out evaluation and moderation training sessions, and that being actually the training material in that case used by HS2 was actually part of the court case and was looked at. So really important to do. And why is that all important? Because ultimately that written rationale that is the output of the moderation process will be used, if it's done properly, that should be what's used then to generate your final standstill letters under current legislation or assessment summaries under the new legislation. And I don't have time to go into it, but I think it's even more important that it's done properly at the moderation stage for the new legislation because of the way the assessment summary process works under the Procurement Act. You'll use that to send it to the winning bidder, but more importantly, the unsuccessful bidders as well. And that is often the point at which someone might, during that standstill period, someone might pick up on something where they think, oh, actually, I don't agree with that score. I don't agree with how you've applied the published criteria. So this is really important. And we would say give enough time to do that properly so that it's not a rushed job. Yeah, that's what I'd say on that slide. And I'm very conscious, I'm going to move on to the next couple of slides, but I'm very conscious we've got about a minute left. So on my next slide, I'm just going to really quickly, the key point to note here is that if decision makers need to be involved in certain areas of key commercial or financial significance in your procurement, give just be really mindful of when those decisions are made. So, for example, are vehicles going to be funded by contractors or the council? If the council needs more time and wants to be informed with information from the procurement, just be really careful that that needs to be done in a way that's independent from the evaluation. Just be really careful that when doing that, you are transparent about how that process is being run, the senior decision-making process, and that no bidder is being favored as a result of that. And then my final slide is very timely because spot on at 1 o'clock, we're just going to talk about time management. And again, my takeaway for this is making sure that your procurement timetable, if you are one who sets those up, doesn't just deal with the actual kind of stages of a procurement, but takes into account the mobilization issues that Sally had talked about before and the decision-making and governance issues that I've just talked about now. Because actually, not allowing that time is itself a ground for potentially, it'll likely lead to grounds for challenge. It's also possibly going to make people less interested in the procurement if there's not enough time for mobilizing and for carrying out the procurement. So that is where we'll leave it. Thank you very much for taking part today. If you would like to find out more about some of the things we've talked about today, feel free to check out our website where we do put articles there. Feel free to email us. You'll have our details at the front of the slide. And I've been asked to remind you to please fill in the feedback form, particularly if you enjoyed the session when EMLS sends that around to you. Thank you, everybody.
Thank you.